Hello everyone, welcome to Let's Crack UPSC CSE English. Inspire crash course targeted for Prelims 2021, where we are studying Polity section. Yes, in our today's session, we'll continue with the High Court. Yes, in previous session, we have covered few constitutional provisions related to High Court. Now we'll continue topic in today's session. So before going to start today's lecture, it's my pleasure to welcome you all on Unacademy, India's largest learning platform, where you will get unlimited access for live and recorded classes, structured courses, and daily live classes. It's me, Rushikesh Inamdar, guiding UPSC aspirants from last 8 years. You can follow me on Unacademy, and also you can join our Telegram group using this link. So friends, Unacademy is providing study material in hard copy, that is in 20 books, which created by top UPSC experts, and the worth of rupees 10,000. Yes, so these books you will get free of cost with our minimum 1 year subscription. So you can go with 1 year, 2 year, or 3 year subscription. And now this offer is extended till 20th April. Yes. So friends, do not forget to enroll yourself for our courses, and we are providing mega subscription offer to all aspirants where you can opt for 1 year subscription. You will get validity till next preliminary examination, that is preliminary examination 2022, and in 2 year subscription you will get validity till preliminary examination 2023. Yes, do not forget to use code RBI Live, and this offer is also till 20th April. So hurry up and grab this mega subscription offer. Yes, those aspirants are looking for their preparation plan after their 12th examination, or those aspirants pursuing graduation and started their preparation, they can opt for our iconic subscription. Yes, in this iconic subscription, you will get all the features of Plus courses along with additional features like personal guidance, expert guidelines, and study planner. So my suggestion to all these freshers, they can opt with our iconic subscription. Yes, we are providing paid subscription on our platform, that is Plus subscription and iconic subscription. Yes, in this structured courses and courses prepared by top educators. In this paid courses, you will get 10% discount on our subscription. Yes, just you have to use referral code RBI Live. Even you can use this referral code to get 10% discount in optional subscription as well. Yes, on Unacademy, you can prepare with combo subscription as well for general studies and optional subject. You can opt for 1 year, 2 year, or 3 year plan. Here also you can eligible to get 10% discount using referral code RBI Live. Yes, those aspirants facing financial challenges during their preparation. Yes, or is there any financial hurdle for chase their dream? So Unacademy is providing loan for UPSC preparation. Yes, so you can chase your dream, UPSC dream with Unacademy. So you can apply for loan. The link is given here. Yes. So hurry up and start your preparation. We will help you to achieve your goal. Yes, Unacademy is providing free test series for all aspirants. Just you have to unlock the test series using referral code RBI Live. In this free test series, we will cover complete general studies and current affairs part. Yes, these are the new batches we are going to start for UPSC CSE. 1 year batch, 2 year batches, and NCRT batches. So do not forget to join new batches from 21st April. Yes. And last but not least, Unacademy combat. Yes, we are conducting combat on every Sunday morning 11 a.m. And now this Unacademy combat is available in Hindi medium also. Just you have to enroll for this combat using code RBI Live and you can participate weekly combat by Unacademy, which is known as biggest free scholarship test for UPSC CSE aspirants. Yes friends, so we'll start today's session of High Court. Yes, as we have covered various provisions like basic introductory part, then composition and appointment of High Court judges. Yes, then qualification, oath and salaries, then salaries and allowances, tenure removal and transfer of judges. So in today's session, we'll see further remaining part. So we'll start with acting additional and retired judges. Yes. So we'll start with acting chief justice. Yes, friends. So the president can appoint. Yes. The president can appoint a judge of a high court and as acting chief justice of the high court. Yes, when the office of chief justice of the high court is vacant. Yes, the chief justice of the high court is temporarily absent. The chief justice of the high court is unable to perform the duties of his office. Yes. So, acting chief justice of high court, the president can appoint a judge of a high court as an acting chief justice of the high court when the office of chief justice of the high court is vacant, the chief justice of the high court is temporarily absent, and the chief justice of the high court is unable to perform the duties of his office. In these three scenarios, the president of India can appoint any judge of high court as an acting chief justice of the high court. Yes. Then we'll see additional and acting judges of high court. Yes, the president can appoint duly qualified persons. Yes, criteria is mentioned in the constitution. So the president can appoint duly qualified persons as additional judges of a high court for a temporary period. Yes, and this temporary period is not exceeding 2 years. Yes. Now, so the scenario where there is a temporary increase in the business of the high court, then president can appoint an additional judges. And second scenario, there are areas of work in the high court. Yes, so the president can also appoint a duly qualified person as an acting judge of a high court when judge of that court is unable to perform the duties of his office due to absence or any other reason. Yes, so along with additional judges, the president can also appoint a duly qualified person as an acting judge of a high court when a judge of that high court is unable to perform the duties of his office due to absence or any other reason, appointed to act temporarily as Chief Justice of that High Court. An acting judge holds office until the permanent judge resumes his office. And however, both the additional or acting judge cannot hold office after attaining the age of 62 years. Yes, this clause is also there. So, both the additional and acting judges cannot hold their office after attaining the age of 62 years. Yes. Then, retired judges. Yes. At any time, the Chief Justice of a High Court of a state can request a retired judge of that High Court or any other High Court to act as a judge of the High Court of that state for a temporary period. Yes, the Chief Justice of a High Court. Yes, for example, in any particular state, the Chief Justice of that High Court can request a retired judge of that High Court or any other High Court to act as judge. Yes, for a temporary period. So where he can do so only with the previous consent of the president and also the person to be so appointed. Yes, such a judge is entitled to such allowances as president may determine. Yes, with the permission of president, the Chief Justice of a High Court can request a retired judge to act as a temporary to resume duties for a temporary period. Yes, he will also enjoy all the jurisdiction, powers, privileges of judge of that High Court, but he will not otherwise be deemed to be a judge of that High Court. Yes, this is also provision where if Chief Justice of a High Court need any retired judge to be perform his duties as a judge, so he can request with the previous consent of the president, he can do this. Yes. Now after that, we'll see the important point, that is independence of High Court. Yes, how our judicial system is independent, and already in our chapter of Supreme Court we have covered the independence of Supreme Court. Now in today's session we'll learn about independence of High Court. Yes, the independence of a High Court is very essential for effective discharge of the duties assigned to it. Whenever we are talking about any court, the independence of a judicial system is very essential for the effective of discharge of the duties assigned to it, and it should be free from encroachments, pressures and interferences of the executive, that is Council of Ministers and the legislature. So it should be allowed to do justice without fear and favor. Yes. So the independence of judiciary is very much important to perform his duties. Yes. Which means do justice without fear and favor. So the Constitution has made the following provisions to safeguard and ensure the independent and impartial functioning of a High Court, where first provision is mode of appointment. Yes, so the judges of a High Court are appointed by the President in consultation with the members of the judiciary itself. Yes, so the judges of a High Court are appointed by the President in consultation with the members of the judiciary itself, that is Chief Justice of India and the Chief Justice of the High Court. Yes, there is no interference in the appointment of judges by executive wing. Yes, that is executive and legislature. So this provision curtails the absolute discretion of the executive as well as ensure that the judicial appointments are not based on any political or practical considerations. Yes. Then, second provision for the independence like security of tenure, where the judges of a high court are provided with the security of tenure. Yes, they can be removed from office by the president only in the manner and on the grounds mentioned in the constitution. So this means that they do not hold their office during the pleasure of the president, though they are appointed by him. So this is obvious from the fact that no judge of a high court has been removed so far. Yes, so the judges of high court are provided with the security of tenure. Yes, then fixed service conditions. So the salaries, allowances and privileges, leave and pensions of the judges of a high court are determined from time to time by the parliament, but they cannot be changed to their disadvantage after their appointment except during a financial emergency. So thus the condition of service of the judges of a high court remains same during their term of office. Yes, this is the fixed service conditions. Then expenses charged on consolidated fund of India. Yes, the salaries and allowances of the judges and pensions of the staff. Yes, the salaries, allowances and pensions of the staff as well as the administrative expenses of a high court are charged on the consolidated fund of the state. Yes, not India. It's a consolidated fund of the state. Yes, thus they are non-votable by the state legislature. So friends, the expenses charged on consolidated fund of the state. Yes. So it should be noted here that the pension of a high court, yes, the pension of a high court judge is charged on the consolidated fund of India, not the state. Yes. Now see the difference. The salaries, allowances and pension of the staff as well as administrative expenses of a high court are charged on the consolidated fund of the state, whereas the pension of a high court judges, not salary. Yes, salaries and allowances from the consolidated fund of the state, whereas the pension of a high court judge is charged on the consolidated fund of India. Yes. So just see here, we'll see the salary and allowances from the consolidated fund of state, whereas pension of the high court judges is charged on the consolidated fund of India. Yes. Now, fifth provision for the independent nature or independency feature of the high court, where conduct of judges cannot be discussed. So the constitution prohibits any discussion in the parliament or in state legislature with respect to the conduct of the judges of a high court in the discharge of their duties Yes, except when an impeachment motion is under consideration of the parliament. So normally, our constitution prohibits any discussion in parliament or in state legislature with respect to the conduct of the judges of the high court. Yes. Ban on practice after retirement. Yes, which will ensure the independence. Like the retired permanent judges of a high court are prohibited for pleading or acting in any court or before any authority in India except the Supreme Court and the other high courts. Yes, this ensures that they do not favor anyone in the hope of future favor. So that's why ban on practice after retirement. Then power to punish for its contempt. So a high court can punish any person for its contempt. Thus its actions and decisions cannot be criticized and opposed by anybody. Yes, this power is vested in the high court to maintain its authority, dignity and honor. Yes, power to punish for its contempt. Then freedom to appoint its staff. The Chief Justice of a High Court can appoint officers and servants of the High Court without any interference from the executive, and the Chief Justice of a High Court can also prescribe their conditions of service. Yes. Then its judicial cannot be curtailed. So the jurisdiction, yes, its jurisdiction cannot be curtailed. So the jurisdiction and powers of a high court, in so far as they are specified in the constitution, cannot be curtailed both by the parliament and the state legislature. Yes, but in other respects, the jurisdiction of powers of a high court can be changed both by the parliament and state legislature. Yes. Then separation from executive. The constitution directs the state to take steps to separate the judiciary from the executive in public services, which means that the executive authorities should not possess the judicial powers. So, consequent upon its implementation, the role of executive authorities in judicial administration came to an end. Yes, the Criminal Procedure Code 1973 has effected the separation of judiciary from the executive. Yes, the Article 50 under the Directive Principles of State Policy DPSP. Yes, now after the independence, we'll see the jurisdiction and powers of High Court. Yes, like the Supreme Court, the High Court has been vested with quite extensive and effective powers. Yes, it is the highest court of appeal in the state. It is the protector of the fundamental rights of the citizens. It is vested with the power to interpret the constitution. Besides, it has supervisory and consultative roles. So, however, the constitution does not contain detailed provisions with regard to the jurisdiction and powers of a high court. Yes, it is only laid down that the jurisdiction and powers of a high court are to be the same as immediately before the commencement of the constitution. But there is one addition, that is, the constitution gives a high court jurisdiction over revenue matters. Yes, which did not enjoy in pre-constitutional era. Yes. So the constitution also confers some more additional powers on a high court like writ jurisdiction, power of superintendence, consultative power, etc. So, moreover, it empowers the parliament and the state legislature to change the jurisdiction and powers of a court. So, at present, a high court enjoys following jurisdiction and powers like original jurisdiction, read jurisdiction, appellate jurisdiction, supervisory jurisdiction, control over subordinate courts, a court of record, and power of judicial review. Yes, so the presently High Court enjoys these jurisdictions and powers. Yes. So the present jurisdiction and power of a High Court are governed by the constitutional provisions, the latest patent, the Act of Parliament, the Act of State Legislature, Indian Penal Code 1860, Criminal Procedure Code 1973, and CPC, that is Civil Procedure Code 1908. Yes, so the present jurisdiction and powers of the High Court are governed by all these provisions in the Constitution. Yes, now first we'll see original jurisdiction. So it means the power of a High Court to hear disputes in the first instance, not by way of appeal. Yes, it extends to following like matters of admirability and contempt of court, dispute relating to the election of members of parliament and state legislatures, regarding revenue matter or an act ordered or done in revenue collection. Yes, enforcement of fundamental rights of citizens, cases ordered to be transferred from a subordinate court involving the interpretation of the constitution to its own file. The four high courts have originally civil jurisdiction in cases of higher value, that is Calcutta, Bombay, Madras and Delhi high courts. Yes, these four high courts have original civil jurisdiction in cases of higher value. So, before 1973, the Calcutta, Bombay and Madras high courts also had original criminal jurisdiction, and this was fully abolished by the Criminal Procedure Code 1973. Yes, so it's all about original jurisdiction. Then we'll see the read jurisdiction. So Article 226 of the Constitution, which empowers a High Court to issue writs including habeas corpus, mandamus, certiorari, prohibition and quo warranto for the enforcement of the fundamental rights of the citizen. Yes, and for any other purpose. So the phrase for any other purpose refers to the enforcement of an ordinary legal right. So the High Court can issue writs to any person, authority and government not only within the territorial jurisdiction but also outside the territorial jurisdiction if the cause of action arises within its territorial jurisdiction. Yes, here we have to remember the second provision was added by the 15th Constitutional Amendment Act of 1963. Yes. So it's all about the read jurisdiction of a High Court. So the read jurisdiction of a High Court is not exclusive but concurrent with the read jurisdiction of the Supreme Court. So here we'll see the relation between Article 226 of Indian Constitution and Article 32 Yes, the relation between Article 226 and Article 32 with the writ jurisdiction of a High Court, which is not exclusive but concurrent with the writ jurisdiction of the Supreme Court. Yes, which means when the fundamental rights of a citizen are violated, the aggrieved party has the option of moving either the High Court or the Supreme Court directly. So, however, the writ jurisdiction of the High Court is wider than that of the Supreme Court, and this is because the Supreme Court can issue writs only for the enforcement of fundamental rights and not for any other purpose that it is. It does not extend to a case where the breach of ordinary legal right is alleged. Yes. So, in the Chandrakumar case 1997, the Supreme Court ruled that the writ jurisdiction of both the High Court and the Supreme Court constitute a part of the basic structure of the Constitution. Hence, it cannot be ousted or excluded even by way of an amendment to the Constitution. Yes, so writ jurisdiction is a part of the basic structure of the Constitution of India. Yes. Then, appellate jurisdiction. So, a high court is primarily a court of appeal. It hears appeals against the judgment of subordinate courts functioning in its territorial jurisdiction. It has appellate jurisdiction in both civil and criminal matters. Hence, the appellate jurisdiction of a high court is wider than its original jurisdiction. So, we'll see the civil matters, like the civil appellate jurisdiction of a high court, where first appeals from the orders and judgment of the district courts, additional district courts, and other subordinate courts lie directly to the High Court. So, on both questions of law and fact, if the amount exceeds the stipulated limit. Yes. Second, appeals from the orders and judgment of the district court or other subordinate courts lie to the High Court in the cases involving questions of law only. Yes. Where not questions of fact included in these appeals. So, the Calcutta, Bombay, and Madras High Courts have provision for intra-court appeals when a single judge of the High Court has decided a case. An appeal from such a decision lies to the division bench of the same High Court. Yes. So, appeals from the decisions of the administrative and other tribunals lie to the division bench of the state High Court. In 1997, the Supreme Court ruled that the tribunals are subjected to the writ jurisdiction of the High Court, which consequently it is not possible for an aggrieved person to approach the Supreme Court directly against the decision of the tribunals. Yes. Without first going to the High Courts. Yes, after that, criminal matters. So, the criminal appellate jurisdiction of a High Court, where appeals from the judgment of the session High Courts and additional session courts lie to the High Court if the sentence is one of the imprisonment for more than 7 years. Yes, it should also be noted here that a death sentence, popularly known as a capital punishment, awarded by a sessions court or an additional session court, should be confirmed by the High Court before it can be executed, and whether there is an appeal by the convicted person or not. Yes. So in some cases, specified in various provisions of the Criminal Procedure Code 1973, the appeals from the judgments of the Assistant Sessions Judge, Metropolitan Magistrate, or other Magistrate Judicial lie to the High Court. Yes. So these are the civil and criminal matters appellate before the high courts. Now after that we'll see the supervisory jurisdiction. So high court has the power of superintendence over all courts and tribunals functioning its territorial jurisdiction, which exclude military courts or tribunals. So the high court may call for writings from them, make and issue general rules and prescribe forms for regulating the practice and proceedings of them, prescribe forms in which books, entries and accounts are to be kept by them, and settle the fees payable to the sheriff clerks, officers and legal practitioners of them. Yes, so the supervisory jurisdiction of High Court, where this power of superintendence of High Court is very broad because it extends to all courts and tribunals whether they are subject to the appellate jurisdiction of a High Court or not. It covers not only administrative superintendence but also judicial superintendence. Yes, it is a revisional jurisdiction and it can be suo motu and not necessarily on the application of a party. So, however, this power does not vest the High Court with any unlimited authority over the subordinate courts and tribunals. It is an extraordinary power and hence has to be used most sparingly and not in appropriate cases. Yes, usually it is limited to the excess of jurisdiction. Yes, gross violation of natural justice, error of law, disregard to the law of superior courts, perverse findings, and manifest injustice. Yes. So, this is the supervisory jurisdiction of a High Court. Now we'll see the control over subordinate courts. Yes. The control over subordinate courts, in addition to the appellate jurisdiction, the supervisory jurisdiction over the subordinate courts, as mentioned above, a High Court has an administrative control and other powers over them. So these includes where it is consulted by the governor in the matters of appointment, posting and promotion of district judges, and in appointments of persons to the judicial service of the state. Yes, it deals with the matter of posting, promotion, grant of leave, transfers and discipline of the members of the judicial service of the state other than district judges. Yes, this control over subordinate courts can withdraw a case pending in subordinate court if it involves a substantial question of law that required the interpretation of the Constitution, and it can then either dispose of the case itself or determine the question of law and return the case to the subordinate court with its judgment. Yes, its law is binding on all subordinate courts functioning with its territorial jurisdiction in the same sense as the law declared by the Supreme Court is binding on all courts in India? Yes. So, the law is binding on all subordinate courts functioning within its territorial jurisdiction in the same sense as the law declared by the Supreme Court is binding on all courts in India. So, it's a control over subordinate courts. Then, High Court is a code of record. Yes, as a code of record, High Court has two powers where the judgment, proceedings and acts of the High Court are recorded for perpetual memory and testimony, and these records are admitted to be of evidentiary value and cannot be questioned when produced before any subordinate court. So they are recognized as legal precedents and legal references. Yes, it has power to punish for contempt of court either with the simple imprisonment or with fine or with the both. Yes, so the High Court is code of a record. So the expression of contempt of court has not been defined by the Constitution. However, the expression has been defined by the Contempt of Court Act of 1971. So under this, contempt of court may be civil or criminal. So civil contempt means willful disobedience to any judgment, order, writ or other process of a court, or willful breach of an undertaking given to a court. Yes, so criminal contempt means the publication of any matter or doing an act which scandalizes or lowers the authority of a court, prejudices or interferes with the due course of a judicial proceeding, interferes or obstructs the administration of justice in other manner, any other manner. So these are the criminal contempt. So, however, innocent publication and distribution of some matter which fair and accurate report of judicial proceedings, fair and reasonable criticism of judicial acts, and comment on the administrative side of the judiciary do not amount to contempt of court. So, as a code of record, a high court also have the power to review and correct its own judgment or order or decision. So even though no specific power of review is conferred by it by the Constitution, so the Supreme Court on the other hand has been specifically conferred with the power of review by the Constitution. Yes, this is the difference. So this is a code of record. Yes. Then we'll see a power of judicial review. So judicial review is the power of a high court to examine the constitutionality of legislative enactments and executive orders of both the central and state governments. So on examination, if they are found to be violative of the constitution or ultra vires, they can be declared as illegal, unconstitutional and invalid by the High Court. So consequently, they cannot be enforced by the government. Though the phrase judicial review has nowhere been used in the Constitution, the provisions of Article 13 and Article 226 explicitly confer the power of judicial review on a High Court. Yes, Article 13 and 226 of our Constitution, which confer the power of judicial review on a high court. Yes. So the constitutional validity of legislative enactment or an executive order can be challenged in a high court on the following three grounds: when it infringes the fundamental rights, it is outside the competence of the authority which has framed it, and it is repugnant to the constitutional provisions. So the 42nd Amendment Act of 1976, which curtailed the judicial review power of High Court, and it debarred the High Courts from considering the constitutional validity of any central law. So, however, the 43rd Amendment Act of 1977, which restored the original position, yes. So now, this is the power of judicial review. So we have covered the jurisdiction and powers of High Court. Yes. Where we have covered original jurisdiction, writ jurisdiction, then appellate jurisdiction with civil matters and criminal matters, then supervisory jurisdiction, control over subordinate courts, then High Court is a code of record, then power of judicial review with the reference of Article 13 and 226 of Indian Constitution. Yes. Now we'll see the High Courts of India. Yes. We'll see with the year of establishment, Allahabad was established in 1866. Yes. So Allahabad bench at Lucknow, and territorial jurisdiction is Uttar Pradesh. Then Andhra Pradesh established in 2019, territorial jurisdiction Andhra Pradesh and seat in Amravati. Bombay High Court was established in 1862. Territorial jurisdiction is Maharashtra, Goa, Dadra and Nagar Haveli, and Daman and Diu. So seat at Mumbai. And benches at Nagpur, Panji and Aurangabad. Then Calcutta High Court established in 1862. Yes. The territorial jurisdiction, West Bengal and Andaman Nicobar Islands, which seat at Kolkata and circuit bench at Port Blair. Then Chhattisgarh High Court established in 2000. Territorial jurisdiction is Chhattisgarh and seat at Bilaspur. Then Delhi High Court established in 1966. Territorial jurisdiction Delhi and seat at Delhi. Guwahati High Court was established 1948. Territorial jurisdiction of Assam, Nagaland, Mizoram and Arunachal Pradesh. Seat at Guwahati, where benches at Kohima as well and Itanagar. So Gujarat High Court was established in 1960. The territorial jurisdiction is Gujarat, seat at Ahmedabad. Then Himachal Pradesh, established 1971. Territorial jurisdiction Himachal Pradesh and seat at Simla. Jammu and Kashmir High Court established in 1928. So territorial jurisdiction is Jammu and Kashmir and Ladakh, and seat at Srinagar and Jammu. Then Jharkhand High Court, year of establishment 2000, and territorial jurisdiction Jharkhand, seat at Ranchi. Then Karnataka High Court, established in 1884, territorial jurisdiction Karnataka, and seat at Bengaluru. Kerala High Court, established in 1956, with territorial jurisdiction of Kerala and Lakshadweep, and seat at Ernakulam. Madhya Pradesh High Court, established in 1956 with the territorial jurisdiction of Madhya Pradesh, which seat at Jabalpur, and benches at Gwalior and Indore. Madras High Court was established in 1862, territorial jurisdiction of Tamil Nadu and Puducherry, and seat at Chennai. Then Manipur High Court was established in 2013, where Manipur is the territorial jurisdiction and seat at Imphal. Then Meghalaya, established in 2013, territorial jurisdiction is Meghalaya, and seat at Shillong. Yes, Odisha High Court, established in 1948 with territorial jurisdiction of Odisha and seat at Cuttack. Patna High Court, established in 1916, territorial jurisdiction of Bihar, seat at Patna. Punjab and Haryana, yes, Punjab and Haryana High Court, established in 1875, the territorial jurisdiction of Punjab, Haryana and Chandigarh, and seat at Chandigarh. Then Rajasthan High Court was established in the year 1949 with the territorial jurisdiction of Rajasthan, where seat at Jodhpur and bench at Jaipur. Sikkim, 1947, Sikkim High Court was established in 1975, where Sikkim is the territorial jurisdiction and Gangtok is the place of sit. Telangana High Court was established in 1954. The Telangana is the territorial jurisdiction with seat at Hyderabad. Tripura High Court was established in 2013 with territorial jurisdiction of Tripura and seat at Agartala, whereas Uttarakhand High Court, established in 2000, territorial jurisdiction of Uttarakhand and seat at Nainital. Yes, these are the high courts of India with the year of establishment, territorial jurisdiction, and seat and benches information. Yes. Now, we'll see the articles related to the high courts. So, Article 214, which deals with the high courts for states. Article 215, which describe high courts to be courts of record. Article 216, Constitution of High Courts. Article 217, Appointment and conditions of the office of a judge of a high court. Article 218, Application of certain provisions relating to Supreme Court of High Courts. 219 article deals with the oath and affirmation by judges of High Court. Article 220, Restriction on practice after being a permanent judge. Article 221, which describes salaries of judges. Article 222, Transfer of judge from one high court to another. Article 223, which deals with the appointment of acting Chief Justice. Article 224, which describes appointment of additional and acting judges. Article 224A, which describes appointment of retired judges at sittings of high courts. Article 225, which describes jurisdiction of existing high courts. Article 226, which describes power of high courts to issue certain writs. Yes, Article 227, power of superintendence over all courts by the High Court. Yes, Article 228, transfer of certain cases to High Court. Article 228A, special provisions act to disposal of questions relating to constitutional validity of state laws, and this article was repealed. So, Article 229, officers and servants of the and expenses of high courts mentioned in Article 229. Article 230 deals with the extension of jurisdiction of high courts to union territories. Article 231, establishment of a common high court for two or more states. Yes, and Article 232 was repealed, which was earlier enacted, which describe about interpretation. Now this article is repealed. So this is all about article related to high courts from Article 214 to Article 231. Yes, so with this provisions, friends, we have completed high court topic. Yes, so we'll continue with new topic in our Inspire series, where I'm conducting polity section. So please revise what we have covered till today's session. Do not forget to join our Telegram group. Link is given here. And also you can use referral code RBI Life to get 10% discount in paid subscriptions of Unacademy, that is Plus and Iconic subscription. Yes friends, please like, share and subscribe the videos of Unacademy. And those aspirants are planning to appear for prelims in June, please enroll yourself for free test series by Unacademy. Yes. So that's it for today's session. See you in the next lecture with new topic of polity. Keep studying, keep revising, and take care of yourself. Thank you. All the best.